All rise. This court is now in session. Be seated.
Good afternoon to the party. We want to welcome everyone to the Tennessee Court of Appeals. I'm Judge McClarty. I'll be the presiding judge for this session. We have Judge Frierson and Judge Goldin on this panel also. Are there any preliminary matters to come before the court?
No, Your Honors.
In that case, will the clerk call the first case?
Okay. Buffi Stancil versus Dominion Crossville, LLC.
May it please the court, I'm Brie Stewart. I represent defendants, appellants, Dominion Crossville. And I would like to reserve 5 minutes.
Yeah, and there might be a matter we need to address before we proceed with this case on this issue as to whether or not there is a proper party before this court. Since there's been a suggestion of death, but there has not been an order in it. Is that correct? That's my understanding.
That is correct, Your Honor.
What's the status of that? Did the court ever? I know there was a motion filed.
There was a motion filed, Your Honor. The court granted it, but an order of substitution. Yeah, the order. I think the court did grant the motion to substitute, but I don't think an order of substitution has gone down.
Okay, so that was my initial question, was whether the court actually granted it. There's no dispute about that.
No.
Both sides agree to that.
Yes.
Well, if that's the case, then is there a reason we can't enter a non-pro-tum order if the court's granted it?
We would not have an objection to that, Your Honor.
The question is, would we have an objection to that?
The only concern I would have is that I would think we probably need to have that order entered before we proceed with the case at this point.
I would think if we could go ahead and hear all argument, we couldn't do anything further until that was in.
Okay.
That's what I would think.
If that be approved. Let's go.
So, if y'all, what we'll do is for y'all to get expediently get an order non-pro-tum entered, substituting the party,
That's fine.
and then we can. That's okay.
Yes. We will go ahead and hear you at this time, and we will withhold any action until we receive such order.
Okay.
Make sure we have proper parties before us, and at that time we'll proceed with resolving or making a resolution in the case. Okay?
Okay.
Okay. We're all together. I assume you set aside your time for rebuttal.
Yes, I would like to reserve 5 minutes, and the timer is now at 10. So may it please the court, once again, my name is Brie Stewart. I represent the defendants, Dominion Gentry and Kimberly Burgess-Shalimar, who was the previous executive director of the facility. This case involves the enforceability of an arbitration provision that is contained within a contract for the admission of the decedent, Rebecca Gentry, into my client's assisted living facility. As it's called in the Tennessee statutes, we are an assisted care living facility, and we are under 6811-201. Subsections 4 and 5 is where our regulatory scheme is located. So in Tennessee, where, as in this case, there is a written contract signed by a competent adult, the law presumes that the contract is valid and enforceable. This is consistent with the Tennessee Uniform Arbitration Act, which states that agreements to arbitrate are valid and enforceable unless the party disputing the enforceability of the agreement to arbitrate can prove a defense to the contract, such as unconscionability, incapacity, or some other issue with contract formation. In this case, the trial court denied our motion to compel arbitration on two main grounds. The first is that this assisted living establishment contract was not effective as to Rebecca Gentry because despite the fact that plaintiff appellee signed it on the residence representative line, she was acting in her individual capacity and not as the residence representative. The second ground is that this assisted living establishment contract is a contract of adhesion and was unconscionable and unenforceable. Neither of these findings is supported by the factual record at all. And the application of the law here, particularly the application of the Brzezinski factors and the absence of a contract of adhesion, were clearly erroneous application of applicable Tennessee precedent. As to the first argument, plaintiff essentially attempted to get out of her clear contractual obligation to arbitrate this claim by taking the position that she was signing the contract in her individual capacity, is how the court termed it in his order. She said, "I was signing on behalf of myself" in her deposition when she signed on the residence representative line. Of course, it's our position that the plain language of the contract indicates that she was signing in a representative capacity because she was signing on the residence representative line. And so, of course, her testimony about her understanding or any of this is inapplicable because the contract, by its plain language, is clear and unambiguous.
Excuse me for interrupting, counsel. Was there any reference to power of attorney or the name POA, anything like that with regard to this contract?
So this was an argument that we addressed at length below. So she took the position that she signed other admissions documents with comma POA after her name. We would take the position that the contract itself defines residence representative as someone who has authority via a POA or similar vehicle. And so the fact that she's signing on the residence representative line should not really indicate whether she was signing as POA or not based on the presence or absence of the POA after her signature. Of course, by signing as a representative, you're signing in a representative capacity. Also, it should be noted that the other portions of the record where she's referring to other documents where she put comma POA after her name, none of them had a separate line for residence representative. And so based on the factual record, we think it's clear that she was signing in her representative capacity on behalf of the resident, Rebecca Gentry, when she signed this agreement.
Was this the only document that she signed lacking the POA designation?
I can't think of any that she signed without that designation. It's our position that if you're signing on a line for the representative, the designation is at least implied or clear. And if you look at the definition of residence representative in the document itself, it says that someone who holds authority to assist you with your healthcare decisions or make them for you via a POA or other similar document. So, at this point, it is not disputed that the plaintiff appellant held both a general durable healthcare power of attorney and a healthcare power of attorney to make decisions on behalf of her mother. It's also undisputed that her mother could not have made those decisions for herself at this point. I think if you look at Owens and other applicable precedent on arbitration enforceability, where you hold a healthcare and or general durable power of attorney, you have the authority to enter into these agreements on behalf of the principal. You are an agent. And so our position is when she signed that residence representative line, she bound the people that she was binding, and the agreement itself says all parties, including residence representative, and the facility's manager, all agree to arbitration. Again, the signature by the plaintiff on the residence representative line versus the residence line, this is a sleight of hand that has been attempted in multiple cases and has been specifically rejected. I'll point your honors to the Ricketts case, the Denton case, and other cases which have specifically said that just because you sign on the wrong line doesn't mean that you didn't mean to bind both yourself or the principal where you're the agent. and that to find that a contract is unenforceable because you've signed on the wrong line elevates form over substance and gives into a technicality, when really what we should be doing is interpreting these contracts in such a way that they bind the parties to the things that they intended to be bound. Again, the second basis for the court's denial of our motion to compel arbitration is based on the fact that the court found that this was a contract of adhesion and therefore applied the Brzezinski factors and held that this contract is unenforceable. When we look at adhesion, we are looking to see whether the person who signed the contract had an absence of meaningful choice with respect to whether to sign the contract or walk away. In this case, there's ample proof that they had multiple choices as far as assisted care living facilities in which to place the decedent to receive care at an assisted living level. There's been some positions taken in briefs that just aren't supported by the facts that there was some urgency on the part of plaintiff to get the decedent into an assisted care living facility because winter was coming and she was wandering. There's absolutely no support for that in the record. When I asked Buffi Stancil specifically in her deposition what led to her admitting her mother to Dominion Gentry at that time, she said, well, I wanted to get her to a place that was closer to my home. I wanted to get her to a place that had a dedicated activities director. And she also said that she wanted to move her mother because she trusted the lady who did the admissions, the executive director. None of these facts are sufficient to demonstrate the kind of urgency that the Tennessee Court of Appeals and the Tennessee Supreme Court has thus far required in order to find adhesion.
But isn't it correct that there was actually only one other place that had an assisted living that had a memory care?
So that's not correct. There were several other facilities. There was one place where the decedent was actually living. It was located across the street within the same assisted living complex. So clearly that was a viable alternative because she was actually living there at that time. And also the proof is that there were several other nursing homes in the area. I mean, this plaintiff is a...
This wasn't a nursing home, though, wasn't it? This was an assisted living facility. I mean, I think...
That's correct.
I think when you're making that argument, you need to try and compare apples and apples and not apples and oranges, because that's a fairly significant factor in what we're talking about here.
I mean, what I'm doing is I'm listing the apples that the plaintiff listed when I asked her in her deposition about what other options there were in the area for locked memory units to give her mother the level of care she wanted to get.
Well, when I looked at her deposition, there was only one other facility, and it was this Upland facility that was affiliated with the home care facility she was staying in. And in addition to the factors that you mentioned, she did say, she said, and they were just getting started. This was a new facility, the Upland facility, and that they were sharing the activities, the girl from the assisted living and the memory care. So I was afraid there wouldn't be enough activity to try to stimulate her mind. So that was a significant factor in her mind, wasn't it?
I think that whether that was a factor in her mind, she did say that in her deposition, but at this point, what we're talking about when we look at the cases who have found adhesion in the context of moving a patient into a level of care such as a nursing home or assisted living, we're talking about mom broke her hip and had to have surgery and needs this care, and there's only this one bed within this community. There's absolutely no proof that her mother could not have gotten adequate care at the Uplands facility. And in fact, when I asked her whether she had any concerns with the care her mother was getting at that same complex, she said no.
What, wasn't one of the reasons that she was moving her was because her mother had wandered away a couple of times from that other facility?
She had.
She felt like she needed to be in a more restrictive memory care facility?
Yes, and she could have been in that same restrictive memory care facility at the Uplands facility.
But the Uplands facility didn't have a full-time activities director. They only had a part-time activities director.
Well, again, Your Honor, I think...
I'm not saying, I mean, that's a question, I guess that's a question we've got to decide whether that's significant enough, but that was certainly one of the factors that she testified in her deposition, was one of the reasons she wanted her to be in this facility, because it had a full-time activities director.
Yeah, and I mean, again, an activities director is not a clinical position. And so this is not a person who has, you know, a regulatory licensure requirement. And so what we're talking about is people who do activities with the residents. We're not talking about people who render clinical care or monitor the residents for deterioration in their mental health.
She obviously considered that to be significant, because she obviously there were problems with her mother, and she was concerned that there wasn't enough activity, as she said, to stimulate her mind.
Well, let me clarify too that, again, when I asked her whether she had any complaints or concerns about the care that her mother was receiving at Fletcher House, she said under oath, no. There's no proof in the record that she had any safety concerns or anything else characterized by the court in support of its ruling that there was this only one available facility. So I just think there's a lack of factual record here, or lack of proof, which would support that this was her only choice by a preponderance of the evidence.
Thank you.
Thank you. You have your rebuttal time. Yes, ma'am.
May it please the court. My name is Deborah Reardon. I'm here on behalf of the plaintiff appellee, which represents Rebecca Gentry. And I do want to start out by noting there were two instances where Dominion's counsel has represented that we misrepresented the facts in the record, and I do want to clarify those for the court in case there is any question. The first is on page 19 of their brief. Dominion's counsel states that there's no citation to the record, nor is there any evidence from the record to support the statement that Kelly Dodson told Buffi Stancil when she needed to sign documents for herself. Actually, I'm sorry, it's page 10 of their brief. And actually in page 19 of our brief is where we do have those citations to the record that are pages 250 to page 254, which are Buffi Stancil's deposition testimony. And I want to just read for the court real briefly her deposition testimony, which is from page 56 of her deposition, page 51 of the 251 of the record. When you were writing the Buffi L. Stancil POA several times in this packet for Exhibit 5, why did you write POA? Answer, because I was signing for my mother as her power of attorney. Question, so the question is really, did Kelly Dodson tell you to sign it that way, or did you just decide to sign it that way? Answer, I asked her, do I need to sign Mom's name or mine? And she told me to sign Mom's name, me sign as her POA. Question, so it wasn't you deciding in what capacity you were signing? Answer, no. Question, it was just Kelly Dodson telling you how to sign? Answer, yes. Question, would the same be true for the assisted living establishment contract? Answer, yes. Question, you signed whatever, financially responsible party and residence representative? Answer, yes. Question, were you just asking her how you needed to write your name? Answer, yes. Question, okay. Answer, so I signed as myself, not as my mother's POA on that, because it was never said it needed to be.
Excuse me for interrupting, counsel. With reference to that respective section of the contract, I believe it recites Buffi Stancil agrees to act as the financial responsible party and or agrees to act as the residence representative. Are those terms defined in the contract?
Those terms are defined in the contract in sections 17 and 18. They are two different parties to the agreement. And in fact, the Defendants agree on page 28 of their brief that the financially responsible party is an independent party to the agreement, that the financially responsible party is not acting in a representative capacity for the resident. And for the court to also keep in mind, residence representative is a title that Dominion gave to Buffi Stancil. It's not a title she gave to herself. While she was the POA for Buffi Stancil, the residence representative is defined as an individual designated by the resident to assist the resident in making decisions about care, or has been designated to make decisions on the resident's behalf regarding the resident's care. This may include an individual that holds a power of attorney or guardianship. It may also be the financially responsible party. There's no requirement in the assisted living establishment contract that the residence representative hold legal authority to bind the resident. But even more importantly, there's no language within this contract, which you'll see in many other admission agreements to facilities, that by signing this agreement, Buffi Stancil agrees to bind the resident. There's no language anywhere that her signature is binding as to the resident. Instead, she is signing as the title residence representative. There's no mistake. She didn't sign on the wrong line. If she was going to sign for Buffi Stancil, she clearly knew how to do so because she had signed all these other documents as Buffi Stancil as her POA. I mean, as Rebecca Gentry, Buffi Stancil POA. And she didn't do that here because she wasn't told to. In determining a contract interpretation, the real question for the court is whether there was mutual assent, and whether that mutual assent was that Buffi Stancil's signature as residence representative binds Rebecca Gentry. If you look at the four corners of the assisted living establishment contract, there's nothing within the four corners of that contract that says that the signature as the residence representative binds the resident.
How many documents were executed in connection with this admission? Were there numerous documents?
There were numerous documents. Kelly Dodson testified in her deposition that there were numerous documents in addition to this.
How many lacked the designation POA?
Your Honor, in all candor, I'm not sure. I've not personally identified any other ones because the ones that we put into the record were the ones that did show that she knew how to sign as the POA. I don't believe the entire, her whole health care record is included in this record the way that we would normally do that. I think we just included the ones that said POA.
Thank you.
Was the provision to arbitrate, was that a requirement for admission to this facility?
Yes, Your Honor. This requirement to arbitrate is included as, it is on pages 8 and 9 of this 13-page agreement. It was mandatory that arbitration be agreed to as part of the admission. This agreement is not separately initialed or signed. It doesn't stand out in any particular way like you would typically see in arbitration provisions that are contained within admission agreements. They typically will be in bold and say, by signing this arbitration agreement, you're waiving your right to a jury trial, you agree to not pursue any claims in the judicial system. There's no language like that in this. Buffi Stancil testified that she had never heard of arbitration before she signed this agreement. And the terms of this provision don't do anything to explain what arbitration is. It does not reference its relationship to the judicial system or its preclusion of a bench trial. It does not state that arbitration is the exclusive forum for resolution of disputes. It says that arbitration shall be used to resolve disputes, but not that it's exclusive. It does not tell who picks the arbitrator. It does not mention the jury trial waiver at all within that paragraph. The next paragraph of the document does include a jury trial waiver, but it doesn't cross-reference arbitration. It doesn't go back and say, because you agreed to arbitration, you're not going to have a jury trial. They appear to be two completely different independent paragraphs. There is a prohibition of an award of punitive damages within the provision. the arbitration provision says that the parties can receive economic and non-economic damages, but then later in the agreement, it takes away the parties' ability to receive all non-economic damages that would be allowed under Tennessee law. It limits those to $250,000. And it's the plaintiff's represents that this limitation on non-economic damages uniquely benefits Dominion, because Dominion's claims against a resident, were they to have any, would most likely be those for property damage. They would be for billing or a breach of contract, those type of things. A facility is not going to have a personal injury claim against a resident. And so property damage and contract actions do not have the ability to obtain non-economic damages. That would be a personal injury action, which is what a resident would have. And so the limitation on these damages is something that uniquely benefits Dominion, who is the stronger party here. This similar provision, where a arbitration provision is buried within a larger admission agreement, has been held to constitute an adhesion contract in numerous Tennessee appellate decisions, such as Howell versus NHC, Raytieri versus NHC, and Hill versus NHC. And here, the arbitration provision just, it's confusing at best, because it does not explain what arbitration is. It doesn't explain that it prohibits the resident's access to the judicial system. The trial court correctly determined that this adhesion contract is substantively unconscionable as applied to Miss Rebecca Gentry. Now, the Dominion has stated that in order for a court to find a contract to be unconscionable, it has to be both substantively and procedurally unconscionable. And there are federal cases that have held that. However, I would like to point out to the court that the Tennessee Court of Appeals decision in McGregor versus Christian Care Center did find that substantive unconscionability, if it's egregious enough, is enough to declare a arbitration agreement in the healthcare setting to be unconscionable. In that case, there were also limited options. There were 2 facilities that were available to the resident. I think the resident had been denied admission at one of them, which is not a similar fact here. However, it was substantively unconscionable, and in that circumstance, the court did not need to find procedural unconscionability. The plaintiff does argue that there is procedural unconscionability here, however, because of the absence of a meaningful choice. And also, the court should focus on the presentation and relative position of the parties and formation of the contract and whether there was a knowing and voluntary waiver. Again, because this arbitration provision is so confusing, whether or not Buffi Stancil could knowingly and voluntarily have waived her mother's rights, even if she had signed the agreement on her mother's behalf, is unlikely. This was a standardized contract. Kelly Dodson, who was the new executive director at Dominion, acknowledged that she didn't tell Buffi anything about arbitration when she went over the assisted living establishment contract with her. She said she wasn't even really familiar with it, except for the times that she had been admitting with her supervisor. This was the first admission she had done all by herself. And her explanation of what she would have told her, just that they agreed to arbitration, does not constitute a sufficient explanation, especially not to clarify or to remediate the deficiencies of the agreement itself.
Counsel has indicated there was a that there was meaningful choice, and that there were numerous facilities that your client could have gone to. How do you respond to that?
Yes, Your Honor, and That was another matter that council had stated was not supported by the record. It was a fact that we had argued was not supported by the record. However, I would point the court to page 45 of our brief, where we cite several portions of Buffi Stancil's deposition, which are precisely the ones that Your Honor mentioned earlier, that there was an urgency. She had been wandering away outside. She was afraid of the cold weather, she was concerned. She wanted somewhere where she could be safe. There was the Uplands facility, which was a new facility, and as Your Honor noted, she stated in her deposition that their activities director was being shared by the two. She was concerned that her mother would not get the stimulation she needed at this new facility. It was the only other assisted living facility. There were other nursing homes available. The trial court found that the nursing home options were not the same as the assisted living facility options. He recognized the difference in his order that a nursing home provides, and this was a circumstance also where Dominion has stated or has questioned the urgency of the situation, in part because the paperwork was signed on November the 29th. She was admitted on December 2nd. 2 days difference in the signing of the paperwork and her admission, I don't think undermined any urgency of the situation. It was the time of the year that her daughter was concerned about because of it getting colder and her wandering away. I don't know if this court has seen cases, but I know that I have, of nursing homes where a resident has wandered away and then died of hypothermia. She had every right to be concerned and want her mother to be in a safe location, which required more care than what she was currently receiving at Fletcher House. She would not be able to receive that care where she currently was. She had to go to another location. It was either going to be to the Uplands, the new Uplands facility across the street, or it was going to be to Dominion, where she knew the executive director, or it was going to be to a nursing home, which Buffi stated that she did not feel was satisfactory. Thank you.
Thank you.
Just in brief response to several of the arguments made by Ms. Stancil's counsel, just because a facility is new does not make it an unreasonable choice. Just because a facility is sharing an activities director does not make it a reasonable choice. The fact that that facility was sharing an activities director is not proof that her mother's mental health would have deteriorated at any time within any time. Ms. Stancil is not a doctor. There's no proof in the record that the lack of a dedicated activities director would have resulted in any diminution of the care that her mother needed at Uplands. There is simply no proof that there was a lack of meaningful choice, which would be necessary to both find that this is a contract of adhesion and to find that there was procedural unconscionability. I'll point Your Honor to Your Honors to the Philpott case, which considered almost this exact same scenario and held that proof that there were other choices essentially negated unconscionability. Now, going back to the statement about there being a lack of a specific statement that by signing as the resident's representative, she's binding the resident, there's no statement that the manager who signed the contract on behalf of the facility is binding the facility. If we're going to require these specific statements in every single contract in order to render them enforceable, we're going to render a lot of contracts unenforceable. And Tennessee law is clear that we should be interpreting these contracts with a view toward enforceability and interpreting them in such a way as to divine the intent between the parties. And this contract says that in consideration for acting as the resident's representative, she is accepting the respective rights and obligations set forth in the agreement. Now, all parties to the agreement, including the resident, are obligated to arbitrate this claim. I don't think that there's any other way to interpret this contract except to find that by signing as the resident's representative, she was acting in a representative capacity. I think Owens is clear that when you sign a contract on behalf of your healthcare principal as their healthcare agent, and you're signing in a situation where signing that arbitration agreement is necessary to gain admission to a nursing home, that the agent has authority.
Was there any additional consideration given to waive constitutional rights of trial?
Your Honor, the consideration given for all of the terms of the contract is admission of the resident and provision of the services.
There wasn't anything in addition to admission?
Well, it's all a part of the same contract. I'm not sure that there needs to be any additional consideration. I'm not aware of any authority which would require that.
Okay, that's the question. And also, if the contract, if the provision to arbitrate had not been accepted, would she have been admitted?
No, Your Honor, it is required for admission. Now, when it comes to the fact that she had to sign numerous documents, the fact that this provision is not bolded or included in a separate page or document, all of these are Brzezinski factors. And all of those were enacted under circumstances much different than this case. Brzezinski, of course, is a case involving an existing provider-patient relationship. And so the Tennessee Supreme Court decided that as a matter of public policy, we should be requiring these additional safeguards to keep patients from losing their doctors. And in the years since, it has expanded that doctrine to include situations where there is an urgent or pressing need for a patient to gain admission to a nursing home.
In Brzezinski, it was a totally separate document, wasn't it?
It was. And like I said, there are lots of factors in Brzezinski that simply don't apply. But in this case, we have an educated physical therapist who had worked in all of these facilities, knew all of her choices in the area. She's a competent adult, and Tennessee law presumes that she has read and understood the terms of the agreement. And so
She also testified that she didn't even know what arbitration was until the lawsuit was filed.
she testified that, Your Honor, but there's been lots of cases where patients have also testified to that, or their agents, and the Tennessee Supreme Court and Court of Appeals have gone on to enforce the contract by saying, when you sign a contract in Tennessee, you can't then disavow the terms because you say you don't understand them fully. Instead, Tennessee law presumes that you know and understand the terms of the contracts that you sign.
No additional questions?
Thank you.
Thank you very much. I want to thank both of the attorneys for your presentation. Your case has been submitted to the court, except that you are required to present to the court an order, a non-proton order, as we discussed earlier. Okay, and that should be done right away, immediately. Okay. Okay. There's nothing further. The court is